This is the finale of the Angela Garcia case on Crime to Burn. We've discussed the fatal fire that claimed the lives of Angela's 2 children. We've discussed the first trial that ended in a hung jury. We've discussed the second trial with the questionable jailhouse informant that resulted in a second mistrial due to another hung jury. And we began discussing Angela's third trial, where a prosecutor that was later charged with perverting justice by accepting bribes told the jury that Angela had killed her children for money. We discussed that the judge that presided over all 3 of Angela's trials not only had a poor knowledge of the law, but also was later convicted in relation to a corruption case resulting in her own prison sentence. And today I'm going to tell you why prosecutor Rick Bell, a man that now sits as a judge in Cuyahoga County, should be ashamed of himself. After all, the duty of the prosecution isn't to secure a conviction and then protect that conviction at all costs. The duty of the state is to seek truth and justice. In Angela's case, the prosecution based their theories of the fire on junk science, meaning that there was, in actuality, 0 physical evidence that the fire was arson at all. Investigators didn't follow NFPA 921. They didn't conduct a proper investigation or collect evidence that could have either proven their theory or exonerated Angela, and in light of their failure, they created a falsehood and presented it to the jury as fact. Angela's case is one of the most blatant misrepresentations of justice I have seen, and what makes it so egregious is the evidence uncovered about what Rick Bell was doing before he offered Angela Garcia the plea deal that would haunt her for the rest of her life. That deal is what is known as a dark plea, and today we'll explain what it is and why it's so problematic on Crime to Burn. Welcome to Crime to Burn, where we explore the dark city landscape where true crime intersects with arson and criminal negligence. Join us as we sift through the ashes to bring you the story of what really happened. Welcome back to Crime to Burn. I'm April, a fire protection engineer and former firefighter.
And I'm Cabrin. I didn't sign up for this nightmare, but here I am, trapped in a hostile soundscape where the echoes of past frequencies manifest as reality.
Please be sure to listen to the You Should Be Here podcast. In February, I took part in the Or No series based on the popular concept, Do You Love Me? Check Yes or No. That series focuses on domestic violence, and all of the participating podcasters donated their episodes to the series so that the series proceeds can all go to support a charity standing up against domestic violence and human trafficking. It is completely free to listen to, so go search You Should Be Here on your favorite podcast platform, and be sure to leave a comment, a 5-star rating, and/or written review while you're there to help support this worthwhile cause. You can also leave us a 5-star rating and written review on your favorite platform. Our ratings and reviews have been stalled for some time, and it would be a huge help if you would do that. You can also leave comments in Spotify or Podbean on the individual episodes. Subscribe to our YouTube channel. The best thing that you can do is share us with your friends. Podcasting is not free, and we're not asking for financial support. We're only asking for help growing. So when you see content from us, please like it, comment on it, share it, forward it to someone. Any or all of those things helps tell the platform to push our content to more people, so more people hear about us and we can find our audience. There's a tipping point where we will get enough listeners that the podcast will at least be able to cover our monthly expenses, and we're a very long way from that tipping point, so please consider helping us grow. Also, we have 0 downloads in North and South Dakota. Those are the last 2 states we need to hit all 50 states, so if you know those people, will you forward one of these episodes to them? As always, you can email me at crimetoburn@gmail.com with case suggestions, your own fire stories, and feedback on the pod. I will warn you that if you're trying to reach out to me to market your services in editing or podcast promotion, I can't afford you, and I get several of those emails a day, and I don't have time to respond to them all. I'm not being rude, I'm just busy, and it's almost impossible to tell legit companies from the scams, so I can't risk responding and confirming a valid email address and ending up on some mailing list for pumps or mail order brides. I'm definitely not in the market for either of those. But if you're a legit human that wants to share information with me or have a conversation about the podcast or a case, that email address is there for you. And one last piece of news, please go check out the podcast Sasquatch and Sourdough. It is a super fun podcast hosted by a wonderful woman named Christina, and she invited me on her show, and it was super fun. And I don't know the exact drop date for that episode yet, but I will get it for you. So follow us on social media for more information on when that will come out. Okay, back to Angela Garcia. We know she had a house fire that killed her children, and the prosecution said it was arson for financial benefit. They said that she was a promiscuous black mom that didn't want her babies, so she set a fire to kill them for insurance money. Only they never collected any evidence from the scene that they could test for accelerant to confirm their version of the story because they didn't decide the fire was arson until after the house had already been demolished. So instead, they paraded a bunch of, quote, fire experts, unquote, across the witness stand that claimed that they could definitively call the fire arson based on photographs and specific fire signatures that have now all been completely debunked as false. So basically, they had zero credible scientific evidence. Since they couldn't get a conviction from her first trial, in her second trial they brought in a jailhouse informant that received leniency in her own legal issues to testify that Angela had confessed to her while they were in jail together for about 3 weeks. But her second trial also ended in a mistrial and a second hung jury. This might be where prosecutors stood back and admitted that the failure of the investigators to conduct an appropriate investigation and collect evidence to test for accelerant meant that this case was going to be a lost cause. They were not going to be able to meet the burden of proof required for a murder conviction. They could have just taken the conviction for insurance fraud and moved on, but instead, they brought in 2 new prosecutors, a part-time Baptist minister that we find out later used his position to fix court cases in return for bribes because his financial situation as a prosecutor was what he called untenable. But he stood up in front of a court and accused Angela of committing arson and murder for financial gain. Oh, the hypocrisy. And the other prosecutor was a man named Richard Bell. Now, I can't tell you what Mr. Bell's motivations are, but one might presume that back then he may have had his eye on a judgeship since he was later appointed as a circuit court judge in Cuyahoga County. And when prosecutors have their eyes on political advances, a track record of putting away accused murderers sure looks good in the press and makes the public view them as tough on crime. So was Mr. Richard Bell willing to do whatever it took to secure Angela's conviction because of his political motives? Well, I'll leave that up to you. But he agreed to take a case with no physical evidence back to court for the 3rd time. And he brought his black co-counsel to make his accusations that a poor black woman was a monster and a child killer more palatable, because when a charismatic man the same color as the defendant accuses her of being willing to kill her children for money, somehow it's less offensive, I guess. And Rick Bell opened the 3rd trial against Angela by saying, quote, "We represent the smallest and littlest of our citizens that can't speak for themselves."
Like the Lollipop Guild?
Yes, exactly like the Lollipop Guild. Or the Oompa Loompas. And then his co-counsel, Aaron Phillips, got up and called her a predator. And now, they completely changed their theory of the fire, claiming that there were 2 points of origin, one on the stairs and one in the dining room. His, quote, proof, unquote, was a photo that had been available during both of the previous 2 trials and seen and evaluated by all of the experts that testified in the first 2 trials that the dining room was the single point of origin. But suddenly now, this photo is of new interest because they say they just didn't notice in their first evaluation of the evidence that, oh, there's a second point of origin. So they swore in court that this was definitely the point of origin in the dining room. It could only be this point of origin. It had to be arson. And now they're coming back after 2 trials and saying, there's 2 points of origin. Forget what I swore was accurate and could be inarguable in the first 2 trials. Now we're giving you this different story with no different evidence.
How does anybody look at that person as credible after that?
I don't know. And then because the defense did rightfully roast the peanuts out of the experts that were now testifying to this new theory of the fire, Bell also brought in new quote-unquote experts. And one of these new experts actually said, and I quote, "You're asking me if I can look at this pattern and say to myself that's a liquid pour pattern? Yes, I can say that, and I don't care what NFPA says," unquote. So an expert witness said he doesn't care about the scientific method, and his testimony should absolutely not have passed the Daubert test based on that statement alone, but there it was. Someone on the stand claiming they trusted something as reliable as horoscopes and crystals over actual peer-reviewed scientific evidence. He should have been laughed off the stand. He should have burst into flames from the burning shame that he should have been feeling, but sadly neither of those things happened. And he wasn't the only person that should have felt a burning shame for the rest of his life. There's also an ATF agent named Lance Kimmel, who talked about alligatoring, which we've already discussed as a common char pattern in wood after a fire. And according to NFPA 921 and laboratory testings, it is not now, nor has it ever been, a positive sign of an accelerant. When questioned about NFPA 921's views about alligatoring in the lab testing, he attempted to downplay the authority of the National Fire Protection Association on the stand. Note that since then, NFPA has withstood the scrutiny of scientific confirmation, and people like Lance Kimmel, well, he looks like the kind of guy a podcast would talk smack about in 2025 for his criticism of science.
But what can we say about his mom?
Oh, I'm sure his mom is ashamed of him. How are your old wives' tales holding up now, Lance? Y'all, don't get up on a witness stand and fart nonsense that has been scientifically disproven. It makes you look unethical, unteachable, and unbelievably stupid. And then there was additional testimony from a former FBI agent named Greg McCrary and Ronald Saunders, who was a forensic auditor with the ATF. Now, their testimony was so bat poop insane, I'm not even going to tell you because it was actually thrown out on appeal because it was deemed to have been improperly admitted. But you can always dig into the case yourself and determine what they said.
I think Ronald Sanders sounds like Kentucky Fried Chicken and McDonald's had a baby.
It does. But that is one decision of many that our legal eagle, Judge Bridget McCafferty, allowed into the trial that was later overturned on appeal. And then there was Frank Atkins. He was a rookie firefighter. And at this fire, he did respond. And he did not testify in either of the first two trials. But at this third trial, our dear Frankie now testified that he had found a blue Bic lighter on the staircase of the house. But he said he'd never mentioned it to investigators, and he just left it where he found it. He said he didn't think it seemed important. Now we know firefighter Atkins was either lying or hallucinating. At the temperatures that were seen in this fire, which did go to flashover, a Bic lighter would have melted, burned up, or exploded, and this gets proven in laboratory testing. There could not have been a Bic lighter on the stairs unless Frank or one of his colleagues put it there. To try to prove the innocence of their client, the defense hired one of the contributing authors of NFPA 921, Richard Roby. He was a chemical engineer and an expert in combustion and fire behavior. Now, he sat on the stand and pointed out that you can't call a positive hit by an arson detection dog evidence of arson without lab testing, and that the same is true of photographs. You cannot under any circumstance determine if there is actually an accelerant without lab testing, despite what all of these, quote, fire experts, unquote, had testified to. You cannot, no matter how many times you say it, doesn't make it true. You can't do it.
I've seen pictures of, who's that guy that played Forrest Gump?
Tom Hanks.
I've seen him in space on a picture.
Yep, you sure have.
You think he was in space?
Well, according to these fire experts that testified for the prosecution, he must be.
If I ever see him, I'm going to ask him what space was like.
Awesome. I support that. And Roby showed the court video evidence of what happens to a Bic lighter at the temperatures experienced in this fire. In that video experiment, he showed that the lighter would melt, catch fire, and sometimes explode. So there's no way there was a Bic lighter on the stairs. So he proved that this witness for the prosecution was outright lying. Or he planted the evidence himself, even though he didn't pick it up. So we can't trust that guy's testimony at all. And remember how I told you that Angela had an ADT alarm system and they had called after receiving a tamper and that somebody had answered the phone? This was the state's basis for indicating that Angela had lied about her story of being upstairs when she discovered the fire and going out the upstairs window, because the only phone in the house was a landline downstairs, and so she would have had to have been downstairs to answer the phone. Well, Roby showed up in court to explain that too. He had actually done testing and proved that if someone called when a house's landline phone wires were exposed to fire and the wires shorted out, it completed the circuit answering the call, which would explain why the line was open for 12 seconds with no one talking. And then, if the caller hung up and called back, as ADT did, now that the circuit had already been completed from the first call, the caller got a busy signal the second time, which is exactly what happened in Angela's case. So this eliminates the state's assertion that Angela had to be lying. So now they have a firefighter we've proven is lying, and we've proven that Angela's timeline is feasible. To me, this introduces more than enough reasonable doubt for an acquittal. And that's not all that the experiment showed. Because of the time that the fire would have had to go to flashover to cause that short, it also confirmed Angela's timeline of how fast the fire had moved, backing up her story that by the time she came out of the bathroom upstairs, the smoke was already becoming too thick upstairs to see and was choking her, which the prosecution had been saying wasn't possible for the fire to grow that fast. So with Roby explaining to the jury how fire signatures cannot be deemed proof of a fire and his experiments that were videotaped and cast even more than adequate reasonable doubt on the state's case, the state has three options. They can admit how horrifically flawed their case is, and I think we can see from the fact that we're on a third trial here that they're not going to do that. They're like a pit bull with a T-bone. Or they could have countered the evidence with scientific evidence that disproved it, but they couldn't do that because there was no scientific evidence to back up what they were asserting. So they went for option 3, which was accuse Roby of being a complete fraud. Now, Roby had testified about his experience in order to classify himself as an expert witness. And part of his testimony was that he had been a firefighter in Michigan and a fire instructor in New York in the 1970s and 1980s. So Bell claimed that he couldn't confirm these credentials, and he brought in 2 random chiefs from Michigan and New York as rebuttal witnesses to say that they didn't recognize Roby. Now, I was a firefighter in PG County, Maryland. If I went to PG County and asked any random firefighter that wasn't in my department if they recognized me, they would say no. This is like the most insane rebuttal. I can't even understand how it flew in court to begin with. Anyway, that accusation occurred on a Friday. Those rebuttal witnesses showed up on Friday.
Do you think that's like saying, if you don't know some random guy in Africa, you're not black?
Yep. That's basically how offensive I think this is.
It's kind of f***ed up.
It is very f***ed up. So those witnesses testified that they didn't recognize Roby on a Friday. So the jury spent all weekend believing that Roby was some sort of fraud. But on Monday, the defense brought in people from those departments that could confirm his experience, but they believe that the damage was already done and that the jury had already largely dismissed his testimony as fraudulent based on how, honestly, in my opinion, nefariously the prosecution had gone after him. So basically, Bell did everything he could to convince the jury that the actual expert was peddling junk science and that his experts that were no better than just spouting old wives' tales were the only trustworthy people in the courtroom. In fact, it was Bell that had the monopoly on junk science peddling at this trial. So we have problems with the state's case in terms of the fact that they've just reinterpreted evidence for a completely new story of how the fire happened. And they had the same experts who once testified that they were 100% positive the point of origin was the dining room, now change their story and say now they're 100% positive of a different thing, and nobody questioned that, which means that those experts were either idiots or they were intentionally lying. I'll let you decide. Then we have the fact that the investigation was just a complete disaster because the people responsible with conducting the investigation did not collect any evidence. The dog didn't indicate that there was an accelerant, so they ruled the fire accidental to begin with. They collected no evidence, the house was destroyed, and it wasn't until they got information about the insurance paperwork that they started to change their opinion. Add to that the highly suspect jailhouse informant, a prosecutor that was later accused of accepting bribes on the side, and a judge that clearly can't understand how to apply Daubert and is also later going to be tried and convicted for her actions related to a corruption scandal. And it's obvious that the deck was stacked against Angela in a way that is not fair nor impartial. And we haven't even gotten to the issue of the jury. In the third trial, there was absolutely an issue with the jury. During the trial, the judge received a note from the jury, and here's what it said, quote, "Your Honor, because I work in the immediate area of the burnt home, I feel grave concern for me and my family's personal safety. The family of the defendant owns property in the neighboring area and can easily identify me, especially since we are in the same business. The propensity for contact, visual or physical, is highly likely. It is my feeling, as well as those of my fellow jurors, that I be removed from the jury." Now, this letter was signed by 3 additional jurors, which meant that they had to be discussing the case amongst themselves, which was not allowed. All discussions of the case during deliberations are to be in the room with the entire jury, in attendance, and participating in the discussion. But that's not even the biggest issue. A juror told the judge that they feared for their safety, which could absolutely impact the way a juror decides. Now, what's interesting to me is that in the appeals, the judge dismissed this because Angela was found guilty, and they said that if the person was afraid of Angela's family, that they would have expected this person to feel that they needed to give a not guilty verdict. But that isn't necessarily what the juror meant, and we can't know because the court didn't perform voir dire to ascertain the nature of this juror's concerns. But through my research, I discovered that Angela's stepdad's first wife still lived in the area, and that side of his family held a lot of animosity for Angela's mom and her family. And so this juror may have been referring to that relationship just as much as they could have been referring to Angela's immediate family, meaning that they may have felt pressured to give a guilty verdict. But the judge didn't do their due diligence, and all the appellate courts dismissed it as having no basis. So this was a tainted jury pool. There's just no other way to describe it. Now, on May 24th, 2001, Angela Garcia was convicted by the jury on the state's third trial against her. Her conviction was for 4 counts of aggravated murder, 2 counts of murder, and 3 counts of arson. The Honorable Judge McCafferty, that later would be convicted for her own role in perverting justice and lying to the FBI in relation to a corruption probe, sat at the bench and accused Garcia of treating her daughters, quote, like coins in a slot machine, unquote, and then sentenced her to 2 life sentences. She would be eligible for parole after 49 and a half years when she was 72 years old.
What does that mean?
What does what mean?
Coins in a slot machine.
Saying that she intentionally killed her daughters for money, like she was gambling with their lives in order to get a big payday.
Oh.
See, she's not even good at analogies. She's not good at the law, she's not good at analogies, and she certainly can't tell the truth.
It is a disappointing analogy.
It really is. So Garcia's attorneys appealed the court's ruling, but it wasn't until 14 years later, in 2015, that Garcia finally won an evidentiary hearing through the Ohio Public Defender's Wrongful Conviction Project. They claimed that Garcia was entitled to a new trial because of all of the now debunked arson investigation myths upon which the state based their case. And the morning before Garcia's trial was to take place, the prosecution made an offer. Plead guilty to voluntary manslaughter and get out of prison in just 6 more years. Now, the alternative was to risk another trial. So imagine for a minute how much trauma and pain Garcia had gone through, being called a monster and a predator and being accused of murdering her own children for money, and then watching the state parade people across the witness stand that were just willing to tell bald-faced lies. So imagine how helpless she felt, watching the state pick apart her defense and call all of her legitimate defense measures lies and fraud. And here she is facing a new hearing to see if she could get a new trial. And if she won, she would have to go through all of that again after 3 juries of her peers had already failed her. And she'd been in prison for a long time. She had lost her stepdad, and her mom was aging, and she was scared to death she would not get out of prison before her mom passed. And if Angela was granted a new trial and lost, she would have to serve another 27 years before she would be eligible for parole. So the prosecution made this offer, guaranteeing her freedom in 6 years, but she had to plead guilty.
Well, that sounds like a great deal.
And that's why it's called a dark plea. They give the defendants in these cases a very short timeline to make a horrific decision after they've already been so traumatized by a legal system that didn't treat them fairly. Would you want to go through a 4th trial after everything she'd been through? I can totally understand why she accepted this deal.
That pisses me off.
It should. Now, when the state offers deals like this, they're often referred to as a dark plea. Plead guilty to a crime you didn't commit and win your freedom. And it's really not an easy choice. A guaranteed 6 more years and then release, or risk being wrongfully convicted again. And to add pressure, the defendants usually offered these deals with a very short timeline to accept or reject the plea. Now, Angela made the decision to accept the plea without fully comprehending the ramifications of her choice. Because she was pleading guilty, she wasn't going to ever be exonerated. Her record would forever show she was a felon, impacting her ability to get jobs, apply for leases, to get apartments. In addition, because she pled guilty, there would be no legal recourse to file for restitution for a wrongful conviction. She would be barred from that pursuit because she wasn't exonerated. She was guilty in the eyes of the law. But Garcia accepted the plea in an effort to ensure that she didn't lose another parent while she was incarcerated. But why did the prosecution offer Garcia a plea anyway if they were so confident in their case? Well, I can answer that question. They weren't confident in their case. Remember when we talked about what the duty of a prosecutor is? It's to seek justice and truth, and it's not to protect their convictions at any cost. Well, no one apparently told Richard Bell this little tidbit, because Richard Bell knew going into this evidentiary hearing that his case was flawed. He knew that the science in his case was based on junk, but he wasn't willing to seek the truth. He wanted to protect his conviction. And recall, as I tell you exactly what he did, that Richard Bell was later seated as a judge in Cuyahoga County, where he still sits as a judge. I imagine it probably would have looked bad for his political career to admit that he'd been so horrifically wrong and introduced such dubious science as fact in this case. And you might be asking, if Rick didn't know these things were true at the trial, how can we be positive he knows them now? Well, 1 month before Angela's scheduled evidentiary hearing, Rick Bell attended some continuing education training. Now, most licensed professionals have to do some sort of continuing education requirements to maintain their licenses. And Rick Bell decided to obtain his continuing education credits by attending a seminar for prosecutors and attorneys about arson. And in this seminar, 1 month before Angela's evidentiary hearing, he learned all about the falsehoods that investigators had presented in Angela Garcia's case that have all been debunked. He knows from that seminar that he had zero proof that this fire was arson. And the attendance records show not just that he registered for the class, but that he actually showed up and attended the class. He knew that Angela got that evidentiary hearing, and he would be risking his professional reputation if he let it go on. So instead of letting the truth stand, he devised a way to cover up the errors he made in the investigation, offer Angela Garcia a plea deal, banking on the fact that she was so traumatized by her first 3 trials that she wouldn't trust a jury would actually set her free. And he offered her a plea deal he knew that she would probably take, so that his misdeeds and his errors would not be uncovered while he was getting so close to pursuing a judgeship. And Angela took the deal, not knowing that Richard Bell had this information. Richard Bell was not pursuing the truth. He was protecting his conviction despite the truth. Now, Mr. Bell, your behavior offering a plea deal after you attended this training in which there could be no denying that your case was based on nothing more than mythology is nothing short of reprehensible. I sure hope you've gotten your head out of your own gooch since you're now a judge in a court. I know we're supposed to refer to judges as Your Honor, but that title was based on the assumption that judges would behave in an honorable way. So to use that term for you after your successful bid to obtain a plea bargain to avoid having your wrongs aired in front of the court sure does feel like a misnomer. Your behavior may not have been illegal, but it wasn't honorable. 6 years after accepting her dark plea, Angela Garcia walked out of prison a free woman, but she will always now be labeled a convicted felon. It's a title that will haunt her for the rest of her life. Angela Garcia should have been exonerated. The fire investigators should have done a better job and collected evidence at the scene. Prosecutors should have behaved ethically, and the judge should have known the law well enough to properly apply the tests of Daubert, and Rick Bell should have done the honorable thing once he attended that class and learned beyond a shadow of a doubt that these fire signatures are absolute bunk. But Rick Bell wasn't an honorable enough man to do the right thing. Instead, he protected his conviction despite the truth. Angela Garcia was not treated fairly by the justice system, and she paid a price: 22 years of freedom and a lifetime of being labeled as a felon and a child murderer for a fire that has zero evidence of actually being arson.
That makes me want to go find these dudes and skin their sacks.
I'm not saying they don't deserve that.
I'm not going to do it, but it makes me feel like I want to.
So dark pleas are the guilty pleas of defendants that they're pressured to make in order to earn their freedom. It's like dangling a carrot, and it's nothing short of an abuse of power, and it represents a glaring sidestepping of the prosecutorial responsibilities to pursue truth and justice. And Liliana Segura published a second amazing article for The Intercept entitled, quote, "A Cleveland prosecutor swept a wrongful conviction under the rug. Now he's running for judge," unquote, in March of 2020, about Richard Bell's actions in the Garcia case. And Segura did an amazing job picking apart Rick Bell's statements to call out every partial truth and outright bald-faced lie he told about his own conduct in the Garcia case. Look, we already had one Cuyahoga County judge sent to prison for corruption, and this one is telling lies before he even took the bench. Ohio, you know what you have to do come the next election. If Richard Bell isn't going to make right his lies that he told, which are documented between court records and his statements in interviews that have transcripts while he was running for office, then he doesn't deserve to be a judge. A judge that's willing to lie to serve his own self-interests is no better than lying about helping county politicians out with their court cases like Judge McCafferty did. And if he didn't do anything wrong, then why would he lie about his actions? Sure seems like telling lies can be proven through court transcripts that show you're hiding something. Maybe what you're hiding is your knowledge that what you did was reprehensible. And lest anyone go accusing me of libel or slander, I'm going to give you examples, and my sources are in the show notes, and all of these are documented in transcripts. When Bell was running for judge, he was directly asked in an interview, of which a transcript is available, about the plea deal he offered Garcia. And even though he knew the prosecutor's theory of the fire didn't hold up. Now, Bell responded to these questions, saying that the evidence was, quote, right for the time, unquote. No, Rick, it wasn't. By the time you offered her the plea deal, you had attended that class, and you knew at the time that all of it had been debunked. In fact, it had actually been debunked before she was convicted. You just chose to ignore an inconvenient truth that would have revealed the county's errors. Hide them inside a plea deal that punishes the accused for the rest of her life so that your tough-on-crime record stands. But in fact, that's not all. Bell actually hired an independent fire investigator in 2016 prior to the evidentiary hearing before he offered Garcia the plea, and that investigator confirmed in a written report exactly what Bell had learned in the class, that there were significant deficiencies in the scene investigation. Yet in the interview, he said the evidence was, quote, right for the time, unquote. Then Bell went on in his interview to claim that he used ATF experts that, quote, did not use any type of old arson evidence, unquote, on the stand.
That sounds to me like a contradiction in terms.
Well, actually, remember our friend we talked about, Lance Kimmel? He told everyone that alligatoring was a sign of accelerant on the stand, and Rick Bell knew in 2016, just like we all know now, that there is no truth to that. So once again, Rick lied in the interview, saying that they didn't use any type of old arson evidence, but maybe he's just misremembering. And then Bell told interviewers that, quote, Mrs. Garcia had wanted to plead guilty to manslaughter all along, but that the plea deal had been rejected by his office during her initial trials. Well, Mr. Bell, anyone can read court transcripts and see that Garcia specifically refused a plea deal that you offered her during her initial trials because she refused to say that she intentionally killed her children when she didn't, which is exactly what you made her plead to in order to be released from prison. And then you made statements in that interview insinuating that Garcia wanted to plead guilty and that she'd confessed to her attorneys privately her guilt. And he told the editorial board in this interview that, her attorneys can't reveal everything she told them privately. But it's just not true. Garcia has always maintained that, yes, she was guilty of overvaluing her belongings, committing insurance fraud. But she never set the fire and never intentionally killed her babies. And I think Garcia's lawyer, Joanna Sanchez, had quite the graceful response to this assertion by Rick Bell. It certainly is way nicer than what I would have said. She said that Bell's implications are unfounded and reckless. This is the reckless man that Ohio elected and gave a judgeship in Cuyahoga County, and he is still sitting on the bench. And so if you live in that district, and you're a voting person, you have a duty at your next election to fix it.
And look, it will be a tremendous help to your entire state because right now, the kids have made Ohio synonymous with duty. But not the right kind.
And maybe it was because of Rick Bell.
What the skibbity?
Alright, so I spent a good part of this episode hating on Richard Bell, and I think he deserves every piece of criticism I've heaped upon him. But I do want to highlight some good things he's done, because despite his deplorable decisions in the Garcia case, he has done some positive things for Cuyahoga County citizens. So let's just, in the name of fairness and being unbiased, talk about those.
I don't want to. That guy.
Or just it's quick. There was over 4,000 untested rape kits in backlog in the county, and he has pushed for that backlog of rape kits to be tested in Ohio. Some of these kits dated back from 1993, and by 2015, over 2,000 of them had been tested, and it resulted in 968 matches in CODIS, resulting in 204 indictments of rapists.
That's his job. That doesn't make you virtuous. It means you did your job and got paid for it. What, do you want, a cookie?
And this case is why supporting your local innocence projects and legal clinics is so important. So please be sure to check the links in the show notes of this week's case for some ways that you can directly get involved to help fight wrongful convictions and help support formerly incarcerated individuals like Angela that take these dark pleas in order to earn their freedom but won't get any restitution for their wrongful convictions. And you don't have to donate money. Many of these organizations rely on volunteers to help them fundraise, and they offer other volunteer opportunities. Now, we've covered 4 wrongful arson conviction cases: Cameron Todd Willingham, Christine Bunch, Juwan Deering, and now Angela Garcia. And I guarantee that there are others sitting in prison right now wrongfully convicted that need help to prove that their fires were misclassified as arson. So you can actually help these people by sharing this podcast with others, because the more people that learn about the false fire signatures that were once used to declare fires as arson, the better chance these people have of getting the attention of these innocence clinics. And Angela, if you're listening, you deserved better. You did not get a fair trial. You did not get justice. Everyone from the judge to the prosecutors and investigators failed you. And when so many people were so easily able to believe that you were capable of such horrible things, you deserve to hear this. I believe you. As a fire expert, I can attest to the fact that the evidence in this case cannot and never could prove that this fire was arson. I believe you were a pawn in a game of politics and public opinion, and that optics became more important than your rights to a just and fair trial, and that is unconscionable and unacceptable in a civilized society. May your story inspire others to fight for justice and truth. And that's Angela Garcia's story on Crime to Burn. And to the prosecutors that are more interested in protecting convictions than serving truth and justice, you can all go f*** off into the sun. Itchy eyeball.
Want me to lick it?
No.
Oh, yeah. I think there's something over there you need to pick up off the floor. The mediocre background music will cover it up.
I gotta give people's brains a chance to catch up.
I don't think mine's ever going to. I'm not feeling real thinky.
There's the kitty. She wants to be part of the podcast.
That animal is all about obedience.
Okay, we gotta record, so you gotta be quiet.
I can't think if all I can do is focus on what you're saying. I can't focus on what you're saying if that's all I can hear.
Tell me more about hard things.
There's calculus.
What?
I don't know what's wrong with these writers.
Is my voice squeaking?
Every time you say Angela, it does a whistle.
There's a lot of air traffic in our area today.
It's mostly UFOs. I'd like to grow self-peeling mangoes. I mean, eventually it just takes over the entire earth.
I'm waiting for you to swallow.
I think we could probably save a few dollars and just shave that thing. Yeah, I think it's best we leave that to the professionals. I don't want to touch it. That sounded terrible. I just touched that cat earlier. It's not like I won't touch the cat. I like touching the cat.
I love the cat. Sorry.
Sorry, I had a second.
I had a chin itch. It's my fault.
I didn't realize the stunning speed at which you could scratch your chin.
That was the cat. She's behind the bar.
He doesn't get any kudos.
I'd like to tear him a new asshole.
I'm pretty sure Rick Bell is on his way to getting a restraining order against you. He just needs a big hug.
It's a big hug from a boa constrictor.
You know, the person have a spiritual experience.
Oh, I can't say it.
I forgot we talked about that. I don't really feel dirty about it or anything, but I noticed you got the extra padded one.
I did. I didn't want to be uncomfortable.
This is where my director expertise will come in handy.
You gotta be careful and tense, too.
No, that's not true. Why are you camping around all these people? You don't even like camping.
I was camping in college and walked past a campsite on my way to the bathroom. And let's just say that there was obviously extracurricular activities going on in the tent and they should have turned off their light.
It's like one of those shadow shows. Like Austin Powers, he did it best, I think.
Oh, shadows! We're casting a shadow.
What's wrong, Sailor? You should check that guy out.
He's a good lap dog.
He's a large lapdog. If his elbows weren't so sharp. And he always digs them like right into that part of your thigh where like it paralyzes your leg. Maybe you don't have that part
I'm
of
not
your
sure
thigh.
I have that part.
I do. It just feels like my whole leg goes numb when he hits that part.
Now I'm going to be trying to
looking for
find that button.
My paralysis parts.
Look, it's like a fainting goat.
Maybe. I don't know what people are into. I don't want to kink shame anyone. I don't understand.
You get it in a tube. I was supposed to put icing on him. I forgot.
And I put him in the car. I put him in the back seat because that's where he would be safest. And he was like, this thing moves. I need to be in your lap. And so he stepped up between the seats and stepped on a soda can that was apparently still pretty full. It was in the cup holder and it caused the can to crush down and break on one side and it filled the cup holders up with soda.
Oh, you drove around like that?
Well, I didn't notice it until I was on the way to volleyball practice.
You could check my package.
That's actually always on my list.
We like hygiene. Very
So hygienic.
hygienic.
Did you guys bathe like every day? Or was I just a weird kid? Yeah, just throw them all in the tub together. Well, let's get to it. You get the beer, I'll get the other.
Awesome.
Hi everyone, we are the hosts of Like Mother Like Murder, a true crime momcast.
You heard that right. We are a momcast, which is our unique twist in the true crime world.
What sets us aside is that our content is mainly mom related, from missing moms to murdered moms.
To moms who committed the crime, survivors, and more.
We are getting started on our 3rd season with over 100 episodes that you guys can go and binge. I am Rachel.
And I'm Heather. We drop new episodes every Tuesday, wherever you get your podcasts at Like Mother,
Like Murder.